Emperor of France, Napoleon Bonaparte, once said, "Never interrupt your enemies when they're making a mistake." Well, guess what? I have uncovered a doozy of a mistake by the anti-gun lobby in this country, specifically when it comes to the pending U.S. Supreme Court case dealing with the Bumpstock ban. You're not going to want to miss what I figured out when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a two-time nominee for two major categories of the Gundy Awards for 2024. For Top Male Influencer of the Second Amendment and Top Voice of the Second Amendment. Check it out. I'm proud and honored to be nominated for two Gundys this year. I was also nominated for two Gundys last year, and I'm always honored to be recognized by such a great group of people. Okay, folks. So, major mistake by the anti-gunner. Specifically, you've seen a lot of whoop-de-doo, hoo-la-la, bragging and boasting on the anti-gun networks out there, the media, trying to talk about this proposed quote-unquote assault weapon ban, which they're not labeling an assault weapon ban. They're trying to rebrand it. It's not going to work, but we're not going to get into that right now. We're simply going to talk about the GOSAF Act. GOSAF Act. These people spend way too much time coming up with acronyms, but specifically it's the Gas-Operated Semi-Automatic Firearms Exclusion Act. Just plain stupid all the way around. It's not going to work, but I don't want to talk about the quote-unquote assault weapon components of this. I want to talk about the very specific error they have just made. We can talk about the other things later, but I want to talk about a major mistake they've just made that's going to bite them on the butt immediately, and that meaning the anti-gun movement. Specifically, I'm looking, for example, here at a summary of the GOSAF Act by Arizona Senator Mark Kelly. Obviously, there's several Democratic senators, an independent Senator King from Maine, who's technically an independent, but he caucuses with the Democrats for all intents and purposes, he's a Democrat. Anyway, the bottom line is they made a major concession here that's going to bite them on the butt in front of the U.S. Supreme Court. Specifically, under their list of things they want the GOSAF Act to do, they specifically want to, quote, making conversion devices such as bump stocks and Glock switches unlawful. Now, it is true that the bump stock ban arose during the President Trump era. That is true during that administration. But at this point, it's being defended, of course, by the typical anti-gun lobby, including, of course, the Joe Biden administration, probably the most anti-gun administration in American history, and they are proud of that fact. Now, the problem, of course, is that the anti-gun lobby, with proposing a law, a statute that would outlaw bump stocks, is essentially conceded that the ATF regulatory ban on bump stocks is null and void. It's obvious that if the Democrats thought that bump stock ban by the ATF done through regulatory fiat, if they thought that was on strong legal footing, they would not have to worry about coming up with a statute. But this essentially concedes a critical point, and this is almost certainly going to be brought up during the U.S. Supreme Court case of Cargill versus Garland, dealing with whether or not the bump stock ban, which was brought to us by the ATF through regulations and not through the enactment of a statute, whether or not that's constitutional and legal under, among other things, the Administrative Procedure Act. But now that the Democrats have come out and essentially proposed legislation to ban bump stocks, legislation which, by the way, will not get enacted, at least in the near term. Who knows what will happen years from now, but not right now, for a whole bunch of reasons. But the point is, someone, I'm telling you, at the U.S. Supreme Court during oral argument is likely going to raise the issue of, well, haven't the Democrats just proposed outlawing bump stocks in Capitol Hill like a month or two ago? That's going to be a question posed to Merrick Garland, Solicitor General, is my guess. And I don't know what their answer is going to be. I'm sure they'll say something like, well, we're worried, there was concern here. And then the court's going to push back and say, wait a minute. Why don't you, if you want to enact a bump stock legislation, if you want to ban bump stocks, go to Congress and have them ban it? Why is the ATF trying to do an end run and sneak around Congress? Because it's pretty clear, for two reasons, the U.S. Supreme Court is going to cut back on ATF authority. Number one is the fact they took the bump stock ban case is a very big, significant indication that they're going to cut back on the ATF authority because it's going to be done in conjunction with another pending case before the U.S. Supreme Court right now. That is the Loper-Bright case, which deals with whether or not the Chevron doctrine, which is a Chevron deference doctrine, i.e. courts defer to the interpretation of regulations and statutes that implicate the powers and authority of regulatory agencies such as the ATF. That's what it's all about. And that Loper-Bright case is almost certainly going to give rise to a decision that says the Chevron doctrine, which historically allows great deference to these administrative agencies like the ATF, is going to get thrown into the trash bin of history. At the same time, I think they're going to talk about how this Bumpstock ban brought to us by the ATF without going to the statute, meaning without going to Congress to enact a statute, I think they're also going to use this as an illustrative teaching moment for the administration and for all future presidents, that, again, the notion of Barack Obama that you can rule from the White House with a pen and a phone is not the law of the land anymore, and the U.S. Supreme Court, I think, is going to throw all this out. But what's very interesting here is that this concession, essentially, by the Democrats in the Senate, that the current law that bans bump stocks is a no-go and unlikely to survive the Supreme Court's case that's coming up this term. I think this is a great concession. It is going to be mentioned in several briefs, I'm guessing, before the U.S. Supreme Court, that says that even the anti-gun senators in the U.S. Senate acknowledge that bump stocks have to be banned through legislation, which is why they've just drafted and proposed legislation in December 2023 to ban bump stocks and these other conversion kits. It's going to be a strong indication, it's going to be a concession, admission, if you will, that the current bump stock ban by the ATF is illegal and will not stand. So this is a major mistake by the anti-gun movement. It will be used against them at the U.S. Supreme Court. And again, I think the Napoleon comment about never interrupt your enemy when he's making a mistake, well, I'm glad to see the anti-gunners have made yet another mistake. I think they're trying to throw everything against the wall now. They're not being strategic, and I could not be happier that they are flailing about trying to get some footing in this country on an issue that they slowly or surely but are losing. And again, I think it's pretty clear that the anti-gun movement is flailing about. I think that's great news for us in the Second Amendment movement, that they are not, in my view, being as strategic or organized as they could be. And I think the fact that no one is coordinating or thinking down the chessboard with this pending bump stock case before the U.S. Supreme Court, because if they were doing that, they never would have made this concession with filing legislation on Capitol Hill to ban bump stocks, because they would have gone through the motions of saying, of course we don't need to do that because it's already illegal and the ATF regulation is perfectly fine. But the fact that they went out and did this tells me that they weren't consulting with the Biden administration on this point, or if they did, they just thought the Biden administration is going to get their butt handed to them by the U.S. Supreme Court, as well they should in that bump stock case. But only time will tell. We'll see what happens in the next 6 months or so. All right, folks. Well, I hope you learned something here today at the Four Boxes Diner. Please subscribe and like and follow me, not only here, but also on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.